The Iceman dispute is making fans get cold.
At first, I didn't per se like the nickname. I thought there was cooler nicknames, and then it all kind of came together. My teammates gave me the name. My teammates started calling me it around the facility and things like that, and I just kind of let it fester and let it become what it is now. I wanted to trademark it. I'm trying to do that just to make sure that we can control what's being made and put out about me.
Ownership attorney has entered the chat. On March 16, 2026, Caleb Williams, through his holding company, filed a trademark application with the USPTO for the nickname Iceman in 6 classes covering apparel, sporting good, eyewear, and more. 4 days later, the NBA Hall of Famer George Gervin filed a trademark application through his company for 2 classes covering clothing and entertainment services. The tension has centered around the 2 of them, but a 3rd application may complicate this issue. UFC legend Chuck Liddell filed a trademark, Chuck the Iceman Liddell, back in 2022. Here are 3 lessons from this dispute that actually matter legally. Lesson number 1, Caleb's application for all classes are listed as intent to use. Although Caleb stated he has been using that nickname, it hasn't been used in commerce as a trademark, as noted in the USPTO records. When you file a trademark application with the USPTO, that filing date becomes your priority date. It does confer constructive use of the mark, meaning that the applicant has nationwide priority against others who had not used the mark prior to the filing date. This priority does not override the rights of someone who used the mark in commerce before the filing date and has not abandoned it. That brings me to lesson number 2. Common law rights. George filed for protection in 2 classes. Since his application was submitted after Caleb's, he will have to wait to see what happens with that before he can move forward with his. But he filed an intent to use application for clothing, but he says that he has been using Iceman under common law since 1980 for entertainment and filed an in-use application protection for that. If he has not abandoned that use for that class, his common law rights will give him superior rights to those services. If this is the case, the USPTO will allow George to oppose in whole or part Caleb's application during the opposition period. If Caleb had conducted a clearance search before filing, would he have found that Iceman was being used by George in that class? This brings me to lesson number 3, a clearance search. It reveals what is already in commerce, what is registered and what is not registered. This is a crucial step because not everyone using a mark in commerce is registered with the USPTO. And the USPTO highly suggests doing a clearance search because even after registration, the mark remains subject to legal or equitable defenses from prior use of non-registered marks. A great attorney would not skip this step to identify that. Furthermore, a search would reveal who is registered with the USPTO. Chuck filed his application for clothing and sporting goods. This may cause an issue because Iceman could be considered the dominant portion of his mark for commercial impression. Since he submitted his application 4 years ago and keeps extending the completion date, both Caleb and George may have to wait to see what happens with his application before they move forward. Even if Chuck ultimately loses due to his intent to use status, everyone may be stuck like Chuck if they have to wait for his application to move forward. Caleb may have to wait for Chuck. George will have to wait for Caleb and Chuck. Regardless of whether you have rights, it helps to be proactive in reducing the time and cost of proving them. This is why I'm the ownership attorney.